Hello friends, welcome to week 2 of this MOOC course on conflict management through mediation, where we are dealing with the comparison of judicial process and various other ADI processes. So the topic for today is judicial process versus mediation. As we all know, justice is the foundation and focus of every civilized society. So before getting into the judicial process, let us get to know a bit about the Indian administration system. So the Indian administration is based on three pillars, namely the legislature, the executive and the judiciary. The legislature is the body which is responsible for making the laws. The executive is the body which is responsible for the execution of the laws made by the legislature, and the judiciary is the body which is responsible for interpretation of these laws. It is responsible for dispensation of justice. In India, we have an independent judiciary. That is, the other organs of the government cannot interfere with the functioning of the judiciary. Before you is the illustration of the Indian administration system. So the Indian judiciary is in a pyramid structure with the Supreme Court at the very top, followed by the High Court and then by the District Court and the subordinate courts. This hierarchy has to be kept in mind in case a person wants to file an appeal. So according to this hierarchy only, a person has to approach for any appeal. Let me give you an insight of the judicial process. So imagine that there is a litigation pertaining to a disagreement based on how much building space can be used on individual plots. So the parties to the lawsuits here are senior company executives who keep on meeting each other at business meetings. They gel along with each other and even their families are friends now. So the contention of one party is that the agreement is based on the agreements to restrict full-scale construction. That is, to restrict full-scale construction, no construction at all. And the contention of the other party is based on the denial of the validity of such agreements. That is, the other party denies the validity of such agreements. That is, the validity of agreements promising full-scale construction. So now when the matter goes to court, a lot of evidences are taken and the emphasis is placed on the laws and the provision of laws that apply to the particular case. Now when the court pronounces the decision and the judgment comes, the court permits limited construction. So with this decision, neither of the parties will be satisfied because one party wanted full-scale construction whereas the other party was denying the validity of such agreements. So now these parties will file several motions and appeals. In this process, a lot of time is wasted. So in this process, let's say around 1,000 pages have been filed for pleadings. 34 witnesses have been examined and half a hundred of cases, that is 50 cases, have been cited as precedents. Alongside, 42 days of court's time has been taken for coming to a conclusion. And then also the parties are not satisfied with the result. So, the conclusion that we draw is, the long and short of this example that we have taken from Mr. Sriram Panchu's book is that the court process is a very lengthy process and it is not just taking a person's time and resources, but it also hampers the personal relationship. Because once these parties used to be friends, but now as we can see that they do not even wish to look at each other's faces. Also, it is not just the big corporates who visit the court to get their disputes settled. Whereas other people, private individuals, even the government resorts to the court of law for the resolution of their disputes and administration of justice. Now we'll be talking about the characteristics of judicial process. So the first one is neutrality. So the judge has to be a third party. The third party, which is the judge, it has to be neutral and impartial when it is passing any decision. That is, there has to be no bias towards any of the parties. Next is fair opportunity of being heard. So both the parties to the dispute should be given a fair opportunity of being heard. That is, they should be given a fair opportunity of presenting their side of the story before the court of law. Next is even-handed application of laws and codes. So the judgment which is passed should show the even application of laws and codes, whichever provisions apply to the facts and circumstances of the case. The same provisions have to be applied while passing the judgment. Next is reasoned judgment. So the decision that the court gives has to be a well-reasoned decision following all the legal laws and the procedures. Also, if the court passes any order, it has to be a speaking order. That is, it has to be a well-reasoned order. Otherwise, what happens is it goes against the principles of natural justice. Next is recourse to appellate forum. So if the party is not satisfied with the decision pronounced by the court, then the party can go for appeal. So as we discussed before, there's a hierarchy of courts that exist, and the same hierarchy has to be followed for any appeal that the party wishes to file. Next is principles of natural justice. So a judge has to be guided by the principles of natural justice, that is, justice, equity, and good conscience. Before you is the pictorial representation of all the characteristics of judicial process that we just discussed. Now, when we talk about judicial process, so what is the need to have any alternative? What is the need to have an alternate dispute resolution mechanism? So first of these factors is burden of procedure. So the court process is characterized by numerous and complex rules of law which can only be taken care of by an advocate. So there are laws, the language of laws is complex, and also the practice of courts can only be taken care of by advocates. Next is excessive disputing and polarization. So whenever there is a judicial dispute, the parties enter into a tussle which can create a polarized opinion of a party. Next is winner takes it all. So when we talk about a court process, it is a win-lose situation where one party wins and the other party loses. So the party which wins takes it all, whereas the losing party is left with nothing. Next is litigation lasts. So as we have discussed earlier as well, there is a huge pendency of case, and that is owing to the factor that litigation is a very lengthy and tedious process. Starts from one court, and then if a party wishes to go for appeal, or in between if there are interim orders, which I'll be telling about it later. So all in all it's a very lengthy process which may even extend to months and years. Next is adjudication. When we talk about adjudication, how do we define it? So when we talk about adjudication, it is a state administered system of justice, formal and procedural, where a judge hears both the parties and delivers a binding judgment. So here the key pointers are that it is a state administered system of justice, it is formal and procedural, and the judge has to hear both the parties following the principles of natural justice. A fair opportunity has to be given, as we discussed, and a binding verdict is delivered. Now this whole process, as we discussed earlier also in our illustration, this whole process is very long and is full of technicalities. So now when we talk about the process, it starts with a plaint. Now the aggrieved party files a plaint before the court of jurisdiction, after paying the requisite court fees within the period of limitation. So, before filing a plaint, the aggrieved party has to see whether the court has the jurisdiction, and then it will pay the court fees, and it has to file the suit within the period of limitation. This period of limitation is provided under the Limitation Act of 1963. Now, when the plaint is filed, the opposite party will file a written statement. So what happens is, when a plaint is filed, the court issues a legal notice to the opposite party, and the opposite party in his defense will provide for a written statement. Now, as a reply to the written statement, the aggrieved party can again file a rejoinder. Then the pleadings have to be accompanied with the relevant documents on which the parties rely. Then is the stage of discovery of evidence. So, what happens is that after this, there is a stage of discovery of evidence, and if there are any further documents which are required, then even those documents have to be furnished. Next is the stage of framing of issues. So the responsibility of framing the issues is on the court. So what are these issues? These issues are the point of difference between the parties. So the court has to decide on these issues and pronounce a final verdict. Thereafter, we have the examination of witnesses. So the witnesses have to be examined, and they can be either examined in person or by way of affidavit. And the opposite party has the right to cross-examine the witnesses. So now comes the stage of decision. So after hearing the arguments, the court will pass its decision. If the party is not satisfied with the decision, it can prefer an appeal, and the appeal will be as per the hierarchy that we discussed. Now, we also have one thing called as the interim orders. So, in between the court process, in between the process that we just discussed, there can be instances of interim orders. And if these interim orders are passed by the court, then there can be an appeal against these orders also. Interim orders are basically during the pendency of the suit. And now, the final stages of the execution of the order of the court. So, when the final order is passed, there is a separate process for the execution of the final decree. Now, this execution process is again very complex and lengthy. So, all in all, we also have to know that this complex process has to be taken care by a lawyer, because he is well known to the procedural and the substantive laws and all the intricacies that follow in the law at all stages. Before you is the whole judicial process that we just discussed in a pictorial representation. Now we'll be talking about differentiation. So, the points of difference when we talk about judicial process and mediation. So, when we talk about the first point, it's about the role of the neutral party. So, in a judicial process, this neutral party is the judge, whereas in mediation, the neutral party is the mediator. So, the role of neutral party in case of judicial process is of a decision maker, whereas in mediation, the role is of a guide or a facilitator. Then is the nature of process. So the nature of judicial process is adversarial in nature, whereas the mediation is consensual in nature. Next is decision maker. So in judicial process, the decision maker is the court, whereas in mediation, the decision makers are the parties. Legal rules of procedure. So the legal rules of procedure apply in full, in toto, in case of judicial process. All the laws of procedure have to be followed in a judicial process, whereas these legal rules of procedure do not apply in case of mediation. The role of lawyers. So the role of a lawyer in case of a judicial process is that of advocacy, whereas in case of mediation, the lawyer's role is as an advisor or a participant. Now, the focus of judicial process is on the past acts and establishing the liability, whereas the focus in case of mediation is on the present and future and finding solutions for the same. Next is time. So when we talk about time, the judicial process, as we've discussed earlier, is a very lengthy process and may involve substantial delay, whereas mediation is a quick process. Next is confidentiality. So judicial process is of public record. It is in a public courtroom. It is a public record. Whereas mediation is a very confidential affair. Now the result of judicial process is a judgment. This judgment is appealable as we have discussed before. And in case of mediation, the result is either an agreement or a failure to agree. Next is control. So the judicial process is controlled by a judge, and in mediation, the parties control the decision making. The mediator is in charge of the process. He is in control of the process of mediation, but ultimately the control of the decision is with the parties. Next is cost. So judicial process is a potentially expensive affair, whereas mediation is very reasonable. When we talk about privacy, so judicial process happens in a public courtroom. So if it's not an in-camera proceeding, so we cannot say that judicial process is a private affair. Whereas mediation, on the other hand, is a very private affair. The proceedings are confidential. Then next we talk about satisfaction. So as we discussed, judicial process creates a win-lose situation where the winner takes it all. So the satisfaction is at a lower level, whereas mediation focuses on arriving at an amicable solution for both the parties. So the results are highly satisfactory. Now when we talk about the choice of neutral person, in judicial process, the parties do not have a choice on the choice of the neutral person they want. Whereas in mediation, the choice of the neutral person lies with the parties. Next is how is decision enforced. So in judicial process, the decision is enforced by the court. The execution is done by the court. And in mediation, it can be enforced as an arbitral award if it's required. Termination. So when we talk about termination, a judicial process terminates when the court passes the judgment, whereas mediation either terminates on successful completion or when the termination of mediation is done by either a party or the mediator. Creative solutions. So when we talk about creative solutions, the creative solutions are very unlikely to happen in case of judicial process. Precedents are followed and it's a very formal procedure. Whereas in mediation, there's a high possibility and likeliness and desirability of having creative solutions. As per the facts and circumstances of the case, the needs of the parties, a creative solution can be come up with. Next is flexibility of procedure. So judicial process is a very formal and a rigid procedure. So the flexibility is very limited. Whereas in mediation, there is high level of flexibility depending on the facts and circumstances of the case. Next is effect on relationships. So judicial process tends to deteriorate the personal relationships that the party have. As we discussed in the illustration also, those people used to be friends, but after the lawsuit, their personal relationship got so hampered that they did not even wish to look at each other's faces. But mediation is a very positive way of solving a dispute. The mediator tries to arrive at an amicable solution. So it is very less likely to harm Rather, it is focused more on arriving at an amicable solution. So when we talk about creating precedents, so judicial process no doubt creates precedents which the courts ahead can take up as a guiding factor in the later judgments. But mediation does not give rise to precedents. Every case is new, the needs of every case is new, the parties, their perspectives are new. So every case has to be dealt in its own unique way. Now, when we talk about regulation of practitioners, so there's a considerable regulation of practitioners in case of judicial process. But when we talk about mediation, the regulation of practitioners is limited only to court annexed mediations at present. Now, when we talk about interim relief or urgent relief, then these interim reliefs are possible in case of judicial process. But when we talk about mediation, it is not a process, because the entire mediation process is based on the communication between the parties. The parties need to share their perspectives with each other, and thereafter only an amicable solution can be reached at. So the required time has to be given into the parties to open up, to communicate, to know each other's needs, and then finally arrive at a settlement. Next is deciding or interpreting questions of law. So in judicial process, there is this determination of questions of law. But in mediation, the questions of law are not determined. Next is cost of parties. So in judicial process, the court can award costs to successful parties. But in mediation, usually the cost is equally borne by both the parties. So now we'll be talking about some instances where consensual resolution has helped. So we all must have heard about the Ayodhya Babri Masjid Ram Janmabhoomi dispute, which is the case of M. Siddiqui versus Mahant Suresh Das. So in this case, considering the sensitivity of the dispute, the parties were sent to mediation. Reason being that the outcome would have affected two of the most largest religious communities in India. So mediation helped the parties to understand each other's perspective by way of effective communication and work out with all possible solutions. So this is a classic example of taking help of mediation to solve multidimensional dispute involving communities. Next is the case of K.S. Varghese versus St. Peter's and Paul Syrian Orth. So this is one example of the Malankara church dispute involving distribution of 1,000 churches between two rival communities in Kerala. Now when we talk about the case of B.S. Krishnamurthy versus B.S. Nagaraj, so in this case the Supreme Court directed the family courts to strive to settle matrimonial disputes via mediation and also to introduce the parties to the mediation centers with the consent of the parties, of course, especially in cases concerning maintenance, child custody and related matters. So the parties, so there should be a constant endeavor on part of the family courts to take the parties through mediation centers with the consent of the parties, particularly pertaining to such sensitive matters. Now we'll be dealing with some illustrations. So as you can see in the picture before you, so there's a person murdering the other person. So the question is, A murders B with a knife and runs away. Later he is apprehended by the police. So is this case fit for mediation? So the answer here would be no. The case will not be fit for mediation. It is a criminal case which is absolutely not fit for mediation. Another illustration is, as you can see in the picture before you, this picture is indicative of domestic violence. So the illustration here is, if a case of domestic violence is fit for mediation or not. The answer here is again no. Mediation is all about effective communication and dealing with the situation amicably. That can only be done if the parties are in a position to speak their minds out without any hesitation. But in cases of domestic violence, it is less likely that the parties can open up in a very broad manner. So, domestic violence cases are not advisable for mediation. So this is all for today. I hope you enjoyed the session. Thank you.